The value-added tax legal battle is still raging. Yesterday, the Rivers State government asked the Supreme Court of Nigeria to quash the ruling of the Court of Appeal Abuja Division, which ordered parties to maintain status quo in a suit seeking to determine who has the right to collect value-added tax in Rivers State. However, in a short ruling by the Appellate Court last Friday, presided by Justice Haruna Samani, ordered parties to maintain status quo ante bellum and not give effect to the judgment of Justice Pam. The other was to enable the court hear Lagos State joinder application on Thursday, September 16, by the Lagos State Attorney General before taking the motion for stay and interlocutory injunction. But displeased with the decision, Rivers State yesterday approached the Supreme Court to set aside the ruling of the Appellate Court on grounds that the lower court erred in ordering the status after it earlier held that the application for rejoinder by Lagos State must be heard first before the motion for stay and interlocutory injunction by the FIRS. This is going on tonight. It's now a ding-dong affair.
It was always going to be, though. It was going to end up at the Supreme Court, even in this interlocutory matter or the substantive issue. The Supreme Court was always going to be that court of last resort. But, you know, we're having this conversation off-air one day, you and I, about status quo antebellum. And I was saying I have no idea why in Nigeria we speak of it as antebellum. Elsewhere, it's just status quo ante. But now I see why, because this VAT issue really is a war. They are going to war over this. There are billions, trillions in the long term of Naira at stake. So they are going to take it all the way to the Supreme Court, and I'm not surprised at all.
Dr. Bassey?
Well, you know, on Latinisms in law, I mean, it was one of those exciting things that law faculty students find engaging. Some of them coming from different disciplines. So we like those things. Status quo ante-bellum.
So dramatic.
Quid plantato celucedit.
We all love it.
I once wrote
quad habit.
I once wrote a column on that, but that's on the lighter side. Now, on the question of the value-added tax, 7.5%, the big issue that has been initiated afresh by the Rivers State government is who should collect VAT. Should it be the federal government? Should it be the states? And as we have pointed out before now, there were two cases previously. Issues were raised with regard to that. And now the Rivers State government has provided the necessary leadership. And what we have seen is that the VAT war, in quotes, if any insist, has drawn attention to the politics of restructuring in Nigeria, to the politics of fiscal federalism. And I always make this point, that the truest test of a law is in its implementation. If a law has been implemented even for 20 years, if you don't test it, then of course it will not serve its social purpose. So what we have now is the law on value-added tax being tested, in the court. Although some people say, even VAT as it's operationalized is not in the Constitution. And I guess it's on the basis of that that the FIRS has approached the National Assembly to take a second look at item 58 in the exclusive list, and also to take a second look at section 161. But I've also had others, including former Deputy Senate leader, advising the National Assembly not to go that route, not to use the legislative process as a handmaiden for sabotaging the interests of the subnationals. So the case went all the way from the High Court, two High Courts in Port Harcourt. The Court of Justice Stephen Pam said that, look, is the state reaffirmed the position of the first court. And it's gone to the appeal court, where the appeal court is now saying, well, the status quo should be observed until there is a determination of the motion on notice. Some people have disagreed with that, but that's the position of the law at the moment. And I recall Michael Zekome SAN wrote a piece, an advisory piece, saying, yes, the matter is at this point now, everybody should respect the decision of the court. And now, on the basis of that, the Rivers State government has now gone all the way to the Supreme Court. So it will be interesting to see what the Supreme Court decides. And whatever the Supreme Court pronounces would be the final position on the matter. Before now, the hoteliers in Lagos went all the way to the Supreme Court, and I think they got what they wanted. But now we're dealing with a general thing, something that touches upon the foundations of Nigeria itself and the heart of the national question. But whatever the Supreme Court decides at the end of the day, we should know this, that there are many stakeholders who are not happy with the Nigerian arrangement, that there are many stakeholders who are raising questions about the Nigerian arrangement, not just about the value-added tax, but also, about the union itself, about the status of the union itself. And I think it's important for the government of the day to encourage a conversation around it and not to give the impression that the Nigerian matter is settled. In fact, people get infuriated if you tell them that no, Nigeria is non-negotiable, the union cannot be renegotiated, certain issues cannot be raised. I think what is important, is to continue to have this conversation. Maybe if the government of the day says, well, the conversation will be disruptive, it would, sabotage national security, maybe the judiciary, the last hope of the common man, as the judiciary is ordinarily described, will probably be the saving grace for Nigeria on some of those key questions that divide us, that agitate us, that propel some people to say, in fact, if they will not be listened to, they would rather opt out of the union. So VAT may well be a starting point for further interrogations of the Nigerian state.
As we all know, following the recent judgment of the Federal High Court, Port Harcourt, which upheld the constitutional right and authority of state governments to impose, collect, and utilize value-added taxes, VAT, within their respective territorial jurisdictions, the Rivers State government enacted the Rivers State Value-Added Tax Law 2021 to regulate the effective administration of VAT in Rivers State. As expected, the federal government, through the Federal Inland Revenue Service, FRS, disagreed and filed an appeal coupled with a request for stay of execution of the judgment before the Federal High Court. While the appeal was pending and without any stay of execution of the subsisting judgment, the Federal Inland Revenue Service went about to bully corporate bodies and business entities from paying the VAT to the Rivers State government, even when they knew that an appeal does not serve as a stay, neither was there to stay in a declaratory judgment. As a mere agency of the federal government, without any political authority, the effrontery and impunity exhibited by the FIRS against the Rivers State government was ill-advised and highly provocative. However, being a government that believes in the rule of law, we decided on our own to suspend the enforcement of the Rivers State VAT Law 2021 pending the outcome of the FIRS application for stay of execution before the Federal High Court. Today, the Federal Inland Revenue Service has failed in its attempt to frustrate the enforcement of the state law on VAT with the Federal High Court's dismissal of its application for stay of execution of the judgment. It is important to reiterate the fact that we did no wrong in exercising our legal rights and under our constitutional democracy to stop the continuing breach, denial, and curtailment of constitutional right of to lawfully impose and collect value-added and other related taxes within jurisdiction to the exclusion of the federal government. And in doing so, our singular and progressive objective was to contribute to the advancement of fiscal federalism by enabling the federating states to explore and exploit their potential and capacity for generating greater internal revenues with which to fund their development goals and reduce the outdated over-reliance on pitiable federal allocation and other handouts. Naturally, some states with presently low economic activities and ethically restrictive social policies with economic implications may be adversely affected for now. But this is not our own making. Like the right to derivation, this is also a constitutional prescription which us well as the political leaders to respect and defend as the supreme law of the land. Above all, fiscal federalism remains the right path to economic self-reliance and sustainability for all our states, and the benefit derivable from this case by all the states in the long run far outweigh the immediate revenue loss that some states may presently suffer. All that is required is for all of us to wear our thinking caps as elected governors to collectively fight for the greater devolution of resources, responsibilities, and powers to the federating states. It is therefore very unfortunate that some state governors led by that of Katsina State are vainly conspiring to truncate this progressive reality in favor of the inequitable status quo so that the federal government can continue to rob Peter to pay Paul as the nation's self-imposed tax master general. For us in Rivers State, we will continue to ensure and project our constitutional rights to access all possible resources we can take hold, both within and outside our geographical boundaries, to advance the progress of our state. And with today's judgment, the way is now clear for the administration and enforcement of the Rivers State Value-Added Tax Law 2021 across the entire state until otherwise decided and set aside by the superior courts. Consequently, I hereby direct the Rivers State Revenue Service Board to ensure the full and total implementation and enforcement of this law against all corporate bodies, business entities, and individuals with immediate effect. All corporate bodies, business entities, and individuals are advised to willingly, truthfully, and promptly comply with their tax obligations under this law to avoid the full weight of the stipulated sanctions, including having their business premises sealed up. Let me warn that the Rivers State government is fully in charge of the state and will not tolerate any further attempt by the FIRS to sabotage or undermine our authority to freely administer our tax and other related laws in our own state. Those who play with the fire risk having their fingers burnt. Enough of the shenanigans. I wish to further assure every resident that we shall, as usual, make effective use of the expected proceeds from this tax to accelerate the development of our state and improve the well-being of everyone. Fellow Rivers people, let me also draw your attention to the alarming rate of transmission of the COVID-19 pandemic in our state. The daily figures released from the NCDC show that both the transmission and death rates in the last 2 weeks have consistently been on a rising spiral because residents and visitors to the state have largely abandoned their responsibility to comply with the existing COVID-19 protocols. Clearly, we are headed for a serious health disaster of profound consequences if residents and visitors continue to behave as if the pandemic no longer exists or impotent in Rivers State. This is a big lie, and we cannot afford to continue to close our eyes to the dangers such irresponsible behavior poses to the health, lives, and livelihood of everyone. Accordingly, I wish to remind residents of the subsisting protocols on regular washing of hands and use of alcohol-based sanitizers, maintaining our social distancing, wearing of face masks at all public places, including transport vehicles, and going for immediate testing and treatment whenever you notice any of the symptoms. Furthermore, it has been proven that vaccinations are saving lives here and across the world, and those refusing to take the vaccines for no certified medical reasons should know that they are endangering the rest of the citizens. I therefore appeal to all residents to help protect yourself, your loved ones, and the rest of the citizens by getting their vaccination at the designated health centers in the state. I also appeal to religious leaders and churches to convince and encourage their followers and members to to please go out and take the vaccines and comply with the COVID-19 protocols in addition. Although it remains our desire to keep the state open and allow citizens to go about their social, religious, and economic activities unimpeded, but we may be constrained to reimpose suspended COVID-19 lockdown measures across the state if the transmission of the disease continues to increase beyond tolerable limits. Finally, we wish to reiterate that the ongoing demolition of shanties was born out of the compelling need to safeguard lives and property across the state. Our objective, which is gradually achieving, is to deny the criminals these sanctuaries and hideouts from which they embark on their criminal activities and safely return to. We therefore refuse to be blackmailed by those unpatriotic elements who are trying to stir false ethnic, religious, or tribal sentiments around our patriotic commitment to advance the safety and security of residents. Furthermore, we refuse to be intimidated by such baseless pranks. Rather, we will not rest until we clear the state of all shanties wherever they are located and restore sanity to our environment and achieve a better sense of comfort and security for everyone. Once again, thank you all for your support, prayers, and understanding as we continue to work together to advance our collective security, peace, and progress. Thank you, and may God bless River State.